seconds. Hauhea o kia aha ho kolo kolo ki e hano o ka moku aina o Hawaii. I naui mai, I malio mai, I lohe ia kaleo. Hear ye, hear ye, hear ye, all persons having any business before this Honorable Supreme Court of the State of Hawaii, draw nigh, give your attention, and you shall be heard.
Please call the case.
Case number SCAP-22-0000268. Pualani Kanaka Ole Kanahele, Edward Halealoha Ayel, and Keli'i W. Ione Jr., petitioners, plaintiffs, appellants, versus State of Hawaii Department of Transportation et al., respondents, defendants, appellees. Arguing for appellants, Kanahele et al., Ashley Obrey. Arguing for appellees, Department of Transportation et al., Ewan Rayner. Argument on the merits.
All right, good morning and aloha, everyone. This proceeding is being broadcast live on the Judiciary's YouTube channel as well as on Olelo. I'd like to welcome our substitute justices, Judge Peter Cahill and Judge Clarissa Malinau, and thank them for joining us today. During the proceeding, should a justice have a question, they'll raise their hand virtually and I'll call on them at the earliest opportunity. I'll ask the attorneys to introduce themselves in the order in which they'll be arguing.
Good morning, Chief Justice Rechtenwald, members of the court. I'm Ashley Obrey here on behalf of the appellant.
Thank you.
Good morning, Chief Justice Rechtenwald and Associate Justices of the Supreme Court. My name is Ewan Rayner, arguing on behalf of the state defendant appellees.
All right, we've allotted 30 minutes for each side for argument. Ms. Obrey, you've reserved 12 minutes for rebuttal, so we'll let you know when you've reached the 18-minute point in your initial argument. And again, Mr. Rayner, you'll have 30 minutes, and we'll give you a warning with 2 minutes to go to alert you that you reached the end of your argument period. Ms. Obrey, please proceed.
Thank you, and Velina Mekelo, again, Chief Justice, members of the court. The Department of Transportation's 2018 illegal seizure of Hawaiian homelands is a clear breach of trust, and the beneficiaries must be able to sue to stop it. Today, I want to address the following 3 points. And the first, that the state, including the Department of Transportation, breached its trust duties when it took control of and authority over the Mauna Kea Access Road on March 15, 2018. Second, that the DHHL defendants also breached their trust duties by refusing to exercise their exclusive authority over the road. And third, that the courthouse doors must remain open to beneficiaries like the plaintiff's appellants who sue for relief from the state's breaches. Now, there is no dispute that the defendants breached their trust duties in 2018. That year, for the first time, the Department of Transportation seized control of trust lands underlying the access road, purportedly designated it a state highway, and put it into the state highway system. And this was done in violation of the law, the Hawaiian Homes Commission Act, and the state's highest fiduciary duties, which is the highest trust duties under the law. The defendants, they do not dispute this record of their breaches of trust. The state admits that the access road has been in the Hawaiian homelands inventory since 1929. It is undisputed that up until 2018, it was always acknowledged as trust lands. And on March 15th of that year, the DOT seized the access road via an internal memo between DOT officials without any land disposition approved by the Hawaiian Homes Commission, without any deed of conveyance or any order of condemnation. It is also undisputed that there was no beneficiary consultation with respect to the access road and that no compensation has been paid to the trust. So whatever we want to call the DOT's actions, seizure, taking, theft, we can say that it is an attempted depletion of the trust that violates the terms of the act and is a breach of trust. It is also undisputed that the DHHL defendants did absolutely nothing to protect this land or its beneficiaries' interests. Just like in the Ahuna case, they breached their duties to make the land productive and to act in the best interest of its beneficiaries. Again, none of these facts are disputed below, and defendants have never argued that these are not breaches of trust, and nor can they, because they accepted this kuleana to administer this act with the highest level of accountability, transparency, responsibility as a condition of statehood. These are fundamental duties that are a part of our
Ms.
state
Obrey,
constitution.
may I ask a question? The state characterized, I guess
Sure.
I'd say the state's position is that the status of this land from a functional point of view of the road really hasn't changed for 50 years. It's been used as a highway for public use without compensation since the 70s. That sort of function or role of the highway continued, really unchanged even after 2018. And what interested me is in your reply brief, you looked at the actions which took place in 2018, and you argued that there were material changes in the status of the road, and in particular, DOT's, the Department of Transportation's ability to control the road, to set terms of its use, to require permits, to exclude people, and to initiate criminal proceedings against folks who violate its orders or rules. Can you please explain to me a little bit more about what you believe changed in 2018 that takes us out of the scope of the Act 14 settlement defense that the state is advocating for?
Sure. So as you mentioned, the road has been used for public use for quite some time. And to be clear, that's not something that this lawsuit intends to change. But you're right, the DOT effectively took sticks in the Hawaiian Homeland Trust's bundle of property rights, in effect. These are powers that the Hawaiian Homes Commission never surrendered. Designation, if you look at HRS Chapter 264, gives the Department of Transportation the rights to control, the right to encumber, the right to use the land for non-trust purposes. This includes granting easements within the road and along the road and adjoining other trust lands. So yes, there's this ability to control the road that never existed prior to 2018. And this right was exercised, as we know, in 2019 when they closed the road to the public and even arrested a couple of the plaintiffs in this case. So there was the ability to do that never existed before. As you also mentioned.
I'm sorry. Justice McKenna has a question, but I want to
okay.
let you finish your answer.
Sure. No. So, I mean, I think you covered a lot of what we did put in the brief. And, it really it boils down to the idea of the res judicata. And I can go into that further, but happy to entertain Justice McKenna's question.
Justice McKenna, your question.
Thank you. So, Ms. Obrey, it is your position argument that but for this March 15, 2018 internal transfer, the 2019 road DOT would not have been able to attempt to close the road and make the arrests that they did. Is that right?
Correct. I would argue that it was, it was within the Department of Hawaiian Homeland's jurisdictions at that point.
So if this court were to rule in your favor on remand, what relief is it that you would be requesting? Is it monetary damages and or an injunctive relief, a mandatory injunction, a ruling that the alleged transfer was invalid under the law, and a return of the road to DHHL, basically, I guess, control? The thing is, what are you seeking to do with the prior contract with the county for maintenance of the MKAR?
Okay, so we'll start, I guess, with the general relief that we're seeking. I think, basically, right, reverse and vacate the circuit court's order. We're asking that this court rule on plaintiff's motion for partial summary judgment as it did in Bush. It's something you can do on appeal, and then remand to the circuit court for a decision on damages and injunctive relief. But specifically, we're asking for a declaration that the state defendants breached their trust obligations, violated the Hawaiian Homes Commission Act by asserting control over these lands without compensation, that the state defendants are liable for breaches of trust under HRS Chapter 673, that control of the lands underlying the access road rests solely with DHHL defendants, a declaration that the access road is not a state or public highway, and that a declaration that DHHL defendants also breached their trust obligations and violated the act by failing to address and redress the state's interference with their exclusive control and the rent-free use of the access road. So with respect to the county agreement, I mean, I think it's DHHL's prerogative if they would like the county to continue the maintenance at that point, but the bottom line is that if the lands are in the trust, which we argue they still are because this was an improper designation, that it remain in trust until a proper process is followed. I guess that's my answer.
Could I follow up? You know, the record as to what actually happened in March. I mean, I understand there's a document that shows an internal process was filed at DOT to designate the land. But in terms of as a highway, is there anything in the record that reflects whether the actual, you know, fee simple ownership in the road was transferred, the land under the road was transferred? I didn't see much of anything from the Hawaiian Homeland side to understand, you know, what process, if any, was followed there, other than that joint press statement later on, which indicated, I guess, that the chair of Hawaiian Homelands sort of acknowledged that this was that it was now a DOT or a state road. But what exactly was transferred? And was there in fact a transfer and alienation of the land?
So you're right. In terms of the record, that's it. That's all we have is that internal memo and that later joint press statement. You know, the land with the fee title is in the state. I know that's something the state has argued. This is state land, but it's a special kind of state land. If we look at the idea that the Hawaiian Homes Commission Act, it's a condition of statehood, the state agreed to carry it out. As part of that, there were lands designated as available lands. Those were put into the Hawaiian Homelands Trust. And under the act, DHHL, Hawaiian Homes Commission, they have exclusive authority, and it explicitly says no other agency, no other official has any authority over these lands. So, I mean, I think from that perspective, I mean, we're talking about title here, but it's just a special class of lands that only DHHL can control. And until that land is alienated or otherwise disposed of through some kind of other agreement, that needs to remain the same.
Could DHHL, wholly apart from this lawsuit, reassert control over the lands, or does the transaction that took place in 2018 irrevocable, or does it require the consent of DOT to return the lands to DHHL? That's what I'm. It's, you know, the record is a little is sparse, as you pointed out. So I'm trying to understand exactly what the legal status of that transaction was.
I mean, I would argue that the legal status is that it still is trust lands. I mean, in theory, DHHL should be able to exercise its authority over the land because it never left the trust. Whether so far we just haven't seen them do that, and instead they've acquiesced to kind of the position of the rest of the state, and hasn't stepped forward to support its beneficiaries, kind of giving undue weight to the state, just like in the Ahuna case. I think we kind of see that here today too. Just that it's confusing seeing one attorney representing all these parties with varying interests. Clearly, DHHL has a separate interest from the rest of the state, and yet here we are.
Thank you. Can carry on. I'm sorry, I didn't mean to interrupt.
Sure. No, actually, you took me exactly where I wanted to go in the first place. So, we're talking about kind of like harms to the trust. So 673 doesn't require injury per se, but there is harm to the trust. And in all the ways we talked about, the taking of these sticks in the bundle of rights and this control and authority from DHHL. And as a result of that, there's this inability of DHHL to use the land for infrastructure, for access to nearby lands or homesteading. So it impacts that, impacts their ability to generate income for homesteading. And we know from the Nelson case, lack of revenue has led to astronomical effects on the wait list. In fact, one of the plaintiffs, Plaintiff Ioane, has testified that he's irreparably harmed by any mismanagement that extends his 40-year wait even a day longer. And this court has also recognized that beneficiaries are injured when government breaches their duties when managing trust lands, and again, when interests of the state are given undue weight over the beneficiaries.
It's your position that if DHHL wanted to develop lands for homesteads off that road, I'm not saying they would or they should, but if they did make that decision, it would require the Department of Transportation's approval, and would not have been required up until 2018. Is that your understanding?
Correct. If we act under this purported authority that the DOT has, then that would be the impact on the trust. I would agree.
Come back to damages. What's the period of damages that you're seeking to recover? There's some back and forth in the briefing about damages for the period from 1988, when sovereign immunity, I guess, was waived, going forward to 2018. Is that a period of time you're seeking damages for, or would your damages only be related to 2018 to
2018
now?
till now, through trial, I guess, right? Correct.
Right, thank you.
So, as a trustee,
We have a question from Justice Evans.
Ms. O'Brien, you mentioned you're really just focusing now on the post 2018 alleged breach. As I read the complaint, it reads a little differently. I mean, it seems to me when I look at, for example, in count 2, paragraphs 92, 95, 105 to 107, and some of the relief you're seeking even in the complaint does seem to apply to some of those uncompensable use of the Mauna Kea access road. Are you sort of retracting some of those aspects of your complaint at this point?
yes, we're sticking to the March 15th, 2018 date as the breach, and so anything before that was a notice pleading, and I think we have been consistent since the motion to dismiss and the motion for partial summary judgment and going forward that the operative date is that March 15th, 2018. So we would not be seeking anything before that.
And I noticed, in the complaint, there's no reference to a 26442, and that's the where the director of the Department of Transportation can designate highways in the state system. Can you explain to me how 26442 means that the Mauna Kea access road cannot receive that designation?
Oh, with respect to the unilateral designation, I see. Sorry. Okay. Because under 264-42, let me pull up the language so that I have it right in front of me. Sorry, it's right here. That has to do with, so the director could do it on their own if it's a county highway or other public highway, which we know it was not initially. We were all in the same agreement that it was DHHL trust lands, and which are used primarily for through traffic and not for access to any specific property. And we know here this is an access road, goes one way, goes up to the summit of Mauna Kea. So with respect to that approach, it's improper under that provision of 264.
The way that statute is written, and by the way, it looks like it was a 1965 statute with excess commas and seems like some extraneous information in it, that it's actually quite confusing. So I take it your take is simply that I guess it relates to the through road and the specific property aspects of it. Is Mauna Kea property?
It is, I'm trying to think about it from a Hawaiian perspective as well, and I don't want to say the wrong thing. But
I would probably think you would no, it's not property. Right. And I don't think, that anybody would suggest that it actually is property. So I'm just wondering, there seems to be some, at least in my view, some factual matters to this. Is you have the visitor center, you actually have a DLNR Summit Road up there. And then I'm looking at, through and specific property and trying to deal with those commas. So can you help me out a little bit on the interpretation of that and how it works in your favor?
I would view it as, okay, if we look at what you just said in terms of property, if we say it's not a property, then I guess this road doesn't take us to any property. But it's not a through road. I think of a through road as it takes you from place A to place B, and it gets you across the island or something. And this is just my interpretation. I don't see that here. But I'm kind of getting into the weeds. And I think if we step back and we really think about the fact that this is the Hawaiian homelands, there was never any approval by the Hawaiian Homes Commission to even go through this process, which is like a preliminary step for anything, any kind of disposition with respect to these lands. And of course, no beneficiary consultation, and DHHL is supposed to look out for the best interests of the beneficiaries. 264 almost doesn't matter. We almost don't even get there because they didn't even follow those initial steps correctly. So I think that would be my interpretation.
So I guess in extending to what you just say is, you would suggest to us, if we are going to rule in your favor, that we don't have to wade into that aspect of this case?
I would agree. I would still argue that this was done improperly through 264, but and we would like that declaration that it's not a state highway, but I think you can get there just by recognizing that it was never properly taken out of the trust through the Hawaiian Homes Commission. So it's still in the Hawaiian homelands and not a state highway.
Can I ask you a question about the Hawaiian Homes Commission Act and the use and the disposal of land? And it sort of might dovetail a little bit with what the Chief Justice asked you. It seems like there might be jurisdiction, for example, maybe county control or state control. And is that different than, disposing the land, selling it without compensation or land exchange or anything of that nature?
Sure. Yeah. Historically, yes, we've seen that the state BLN, or the precursor to BLNR, and then BLNR for a while maybe managed the land for a little bit, and then there was an opportunity for it to come back to DHHL officially, and then DHHL decided to have the county help maintain it. All of these things are not the same thing as taking control and ownership. I think it seems pretty clear. I think you can invite someone to use your land, but that's not the same as saying like, oh, now you can say that this is now your land and you can exclude others from it. I wouldn't see that as the same thing. I'm not sure that I answered your question.
No, you did.
Okay.
And, you've mentioned some, I guess, adverse impacts to the designation. And that would be things like perhaps preventing DHHL from easements and roads, or doing what they want to do with the trust property. And I guess I'm also wondering if, could it be sort of a flip side where beneficiaries might say, hey, it's better to have state control over this land than the county control over land, because the state has more resources to operate, maintain it. State has more funding to improve things. Police power issues, since DHHL has no police powers. Could possibly other beneficiaries maybe bring a suit on the other side to say that, hey, it should be state control?
I think that's the problem, is nobody asked the beneficiaries, that nobody asked the Hawaiian Homes Commission to start, or if they did, it's not obvious, or we didn't see that in the record. And nobody asked the beneficiaries what they wanted. And sure, there might be differing opinions within the beneficiary community, but as the trustee of those resources, it's the Hawaiian Homes Commission's kuleana essentially to make the decision of what they think is best, and that didn't happen. So I think that's precisely what's missing from this process. Like, regardless of how they did it, 264, whether it was proper under 264, it was just improper because of the way it just didn't include the beneficiaries.
Ms. Aubrey, Judge Cahill has a question, followed by Justice McKenna.
Ms. Aubrey, my question goes to your statement at the beginning that as a condition of statehood, the state agreed to accept the trust responsibilities, and they would be administered for the beneficiaries through the DHHL. Is it your contention that once that occurred, the state waived sovereign immunity for any claims of breach of trust by the beneficiaries against the DHHL, who are other state entities?
You mean like beyond what any of the laws and acts say?
Yes.
I would love to say that. I think that that's appropriate. I'm trying, this is a responsibility that the federal government gave the state. I mean, really no legislative act should supersede that kind of a big fiduciary duty. We're kind of stuck with, I think, what we have in terms of Act 395 and Act 14, but I like where your head's at, and I think that's appropriate way to look at it.
Trying to unmute myself. Justice McKenna, I think I've successfully unmuted myself, but please go ahead with your question.
Thank you. I just want to make sure I understand which provisions of the Hawaii Homes Commission Act you are arguing were violated through this unilateral DOT memo.
Sure. Let's see. 2.0. I just want to make sure I have them all in front of me before I miss anything. Section 204, for sure. Section, let me make sure I'm correct as well. 206, right? Yeah. And 205 as well. There may be others, but I would say that, because 204 is the control of the Department of Available Lands, 205 kind of gives the restrictions in terms of how you're supposed to think about disposing of these lands, whether it's by lease or sale or anything like that. And 206, we're talking about other officers not controlling Hawaiian homelands. So I think those would be the focus.
Thank you.
Sure.
All right. Anything else at this point, Ms. Aubrey, before we turn to Mr. Rain? We're up to about 25 minutes, but I understand we've taken you well into the time you set aside for rebuttal, but anything else for us at this point, or should we?
I can stop now. Thank you.
Okay.
Appreciate it.
All right, Mr. Rayner, your argument.
Good morning, Chief Justice Rechtenwald and Associate Justices of the Hawaii Supreme Court. My name is Ewan Rayner, Deputy Solicitor General, arguing on behalf of the state defendants. Your Honors, the primary question presented in this appeal is whether plaintiffs' breach of trust claim and the relief that they seek are barred by Act 14 of 1995. And as the Circuit Court properly found, their claims and the relief they seek are barred. Now, Act 14 was an historic piece of legislation that provided for the payment of over $600 million to the Hawaiian Homelands Trust Fund and the transfer of over 17,000 acres to the trust in order to remedy the prior improper taking and use of lands in the Hawaiian Homelands Trust for other public purposes. Now, importantly, Act 14 was intended to fully resolve and finally settle any breach of trust claims arising between August 21st, 1959 and July 1st, 1988, regarding land that was taken for the public use. And as such, the Act bars claims that arise out of any controversies that were existing during that period. Now, the plaintiffs claim in this case that the state's use of the land underlying Mauna Kea Access Road without compensation violated the trust arose prior to July 1st, 1988. The road was built by the government before that date, put into public use before that date by the government and has continued from then until now. And no new claim regarding the disposition of the land or any new harm to the trust arose as a result of the state's designation of the road as a state highway in 2018. The status of Mauna Kea Access Road as a public road was settled by Act 14, and neither the department in this case nor the plaintiffs here are asserting or making a claim that the public use of the road should cease. So ultimately, the only claim that plaintiffs really make in this case is that it's improper for the state to operate Mauna Kea Access Road as a public road without the payment of compensation. But that is exactly what Act 14 sought to resolve.
Mr. Rayner, Justice McKenna has a question.
Thank you. I have several questions, actually. Was there, following up on the Chief Justice's questions, was there any subdivision and transfer of any title to MKAR to DOT?
No. So just to elaborate on that a little bit. So our position is that neither Act 14 nor the 2018 designation actually transferred any title. And so our position is that, even in regard to the 2018 designation, that the land is still within the trust. It hasn't been withdrawn from the trust.
All right. So what is the legal authority on which you rely, on which DOT relies for this internal memo?
So that's HRS 264-42.
All right. So it is your position that this complies with 264-42?
Yes.
What about the Hawaiian Homes Commission Act? Does there not need to be beneficiary consultation and compliance with provisions of the Hawaiian Homes Commission Act in terms of approval by the trustees of this transfer or of this assumption of control?
So,
whatever
essentially, I guess our position on that would be that, absent Act 14, I think that, yes, there would maybe be a claim that this violated the Hawaiian Homes Commission Act. But essentially, the use of Mauna Kea Access Road and the fact that it's been in use as a public road. All right,
so if we were to rule that Act 14 does not bar this, then you are conceding that there is a breach of the Hawaiian Homes Commission Act.
Well, no, we're not conceding that there is a breach of the trust. I mean, this would still have to be remanded to determine whether, I think there are still factual issues that have to be developed to determine whether there is a trust.
Do you agree with Ms. Obrey that if this 2018 transfer had not taken place, DOT would have not had authority to close the roads and arrest the people that were blocking the road?
Certainly DOT wouldn't have had that authority, but the counties would have had authority to arrest people blocking the road pursuant to Hawaii County ordinances that
But were they charged under Hawaii County ordinances?
I'm not 100% sure what they were ultimately charged under. But I guess the point is that if that's part of the alleged harm, then essentially the same result could have occurred regardless of the 2018 designation.
Finally, Ms. Obrey points out what appears to be a conflict of interest between DOT and DHHL defendants here. I'm assuming you have a waiver of conflict?
Well, we don't believe there is a conflict here because the Department of Hawaiian Homelands, is on the same.
So you're saying that the trustees, if they completely acquiesced in this, did not raise any objection. So if we were to conclude that the action was in violation of law, there is a claim for breach of trust against the trustees.
So I'm not sure I understand the question. If you find that there was a violation of law,
you're saying that the DHHL trustees never objected to this procedure at all, the prior trustees or even the current ones.
Right.
And that they're in complete accord that this was a completely proper action taken by the DOT.
Well, I think in light of Act 14 and the belief that the that act settled and brought to final resolution any breach of trust claims that arise out of the use of the road as a public road. And so essentially the position is that the 2018 designation is essentially a continuation of the claim breach of trust that occurred prior to July 1st, 1988, that was resolved through Act 14. So to the extent that they believe there might have been a breach of trust, it's that it occurred prior to July 1st, 1988, and not in 2018.
Mr. Rayner, could you please respond to Ms. Obrey's argument that there were very significant aspects of the sort of right to control that road, in sort of law school terms, the sticks from the bundle of rights that go along with being a owner of property in fee simple, right to exclude, right to arrest, right to, require permits, right to decide whether or not there can be roads attached to that highway that were, in fact, in essence, delegated to or taken by DOT, and that is itself a significant enough change of circumstance to take this outside the scope of Act 14. What's your response?
Right. Well, I guess I have a few points in response to that. And, I think I can try and pass out the different aspects of harm that my opposing counsel argued that resulted from that. So first, is our position that the 2018 designation, it didn't effectuate any transfer title. So we're certainly not taking the position that the 2018 designation transferred title such that it withdrew the lands from the trust.
I'm sorry, it didn't transfer title, but withdrew the lands from the trust?
No, sorry, we're not taking the position that it withdrew the lands from the trust. So the lands are still part of the trust, and essentially what that means is that they could still be subject to a breach of trust claim if there was something that happened that was unrelated to the use of the lands as a road, which is what was settled by Act 14. And so secondly, our position is also that the 2018 designation did not create a public highway where none had existed before. So our position is that Mauna Kea Access Road was, since its construction in the 1970s, always a public highway. And so the 2018 designation was, I guess, more of a administrative change, so that the authority of the road.
The County of Hawaii had the ability to require permits for people who wanted to abut the side of the road. They had I'm looking at the resolution, which from 1983, which talks, as the county council talks about, granted to the County of Hawaii the right to enter the roadway for the purpose of performing maintenance activities. Now, maybe that's not the only dispositive document, but is it your position that all of the rights that Ms. Obrey was talking about, the county had up until 2018?
No, I will acknowledge that the designation, the 2018 designation did give Department of Transportation some authority over the road, which didn't exist in the county before. Now, the county did have some authority to enter the road, to perform maintenance, etc. And like Ms. Obrey argued, there are provisions in Chapter 264 that requires entities like that want to build something adjoining the road or to make any changes to the road would have to obtain permission from Department of Transportation. But I guess, I think that this case has never really been about that. And sort of signifying that, I think the first time that those arguments were raised were actually in the reply brief on appeal. And so those were never really raised or argued below. And I think, essentially, nobody here is seeking to do that. So there's no entity here that's seeking, the Department of Hawaiian Homelands is not seeking to build something or trying to obtain a permit from Department of Transportation. So, our position has always been that this case has been about compensation and the question of how does the trust get compensated for the fact that the road is being used by the state or the county as a public road. And our position has always been and is that Act 14 resolved that question.
Mr. Rayner, Justice Edens, and then Judge Molly now have questions.
You know, Ms. Aubrey brought up some provisions, the Hawaiian Homes Commission Act, and she mentioned 204. And as I look at 204A or 204A3, 205, you know, part of the language says the lands designated as Hawaiian homelands must remain under the control of the DHHL unless the land is sold or exchanged. And then, you know, in 2018, we have the DHHL, the DOT, and the AGs issuing their joint statement that the Mauna Kea Access Road is not or is under the control and jurisdiction of the Department of Transportation. And then essentially they take it over. Then we have the 2019 designation by the director. They have said repeatedly that this is not about the uncompensated use. Act 41 settlement is unrelated to our post 2018 breach. So I'm just wondering how you believe that this is not a new violation of the Hawaiian Homes Commission Act.
Well, so I think we've got to look at the history of Mauna Kea Access Road a little bit. Now, so when Mauna Kea Access Road was built, I think, you know, we can all agree that at that time there wasn't the proper permission or the proper authority taken under the Hawaiian Homes Commission Act. And so, you know, it was built in the 1970s by the state at a time that the land was under the control of Department of Land and Natural Resources. So, and then the road was opened at that time, and only later was then returned to control of the Department of Hawaiian Homelands. So essentially what that means is that the exact same type of breach that is being asserted as occurring in 2018 was the same as the original breach when the road was first built and first opened by the state. And so because that occurred between statehood and between July 1st, 1988, under the terms of Act 14, that is a claim that arose during that period and is one of the claims that was settled by Act 14.
Judge Molly, now your question.
Thank you, CJ. Councils, are there any other instances where roadways are declared as state highways by an internal memo?
No, I believe that's the general practice of Department of Transportation. There's nothing in we don't have anything in the record of any other instances.
All right, and the second question and my final question is, Council, you earlier said that the state takes the position that they're in compliance with 264-42 in designating the Mauna Kea Access Road as a state highway, but in looking at the plain language of that with regards to specific property and access to specific property, how can the state still take that position? So, you know, our position is that the Mauna Kea Access Road, under our interpretation of that provision, is that it is a through road. And if you look at the portion of Mauna Kea Access Road that was actually designated as a state highway, it's the portion from Daniel K. Inouye Highway up to little past the visitor center. So it connects at that point to the Summit Access Road. So essentially it is a road that's connecting on one end to a highway, and then connecting at the other end to another road which continues up to the summit. And along the path of the designated portion of the road, there are also several other connections, the Onitsuka Center, the Visitor Information Center, and several other smaller roads. And so I think, you know, based on that alone, that's sufficient to meet the definition of a through road.
Justice McKenna, your question, and then I had a question. I keep trying to ask it, but for some reason my raised hand keeps getting wiped out. But after you, I'll follow you, Justice McKenna.
Thank you. My question is also on 264-42. It says the Director of Transportation, acting in cooperation with appropriate federal and county agencies, may designate it for inclusion in the state highway system such other public highways, including county highways, which are used primarily for through traffic. Okay, so what type of public highway was this at the time on March 15th, 2018?
At that time, prior to the designation, it was a county highway.
Wait, you said, I thought county highways, you have to actually have a transfer of title to the county.
So the status of
4-2 talks about ownership of public highways, and it says the governor may at any time by executive turn over to any county state land in fee simple for use as a county highway. I thought you said there was no fee simple transfer.
So the state's position has always been that public roads over Hawaiian homelands are public highways, and they're specifically county highways. And just
right,
to the reference,
there was no transfer, correct, to the county fee simple transfer.
There was not a CP simple transfer.
So let's go to 264-1, which seems to define public highway. So what provision, under what provision of 264-1 are you saying this was a public highway? If we ruled that it was not a county highway because there was no transfer in fee simple pursuant to 264-2, and the contract was only for maintenance of the road, what provision of 264-1 makes this a public highway?
So our position is that from when Mauna Kea Access Road was built, because it was built by the state and opened and laid out by the state, it met the definition of a public highway under 264-1A. And you know the land
A1
no.
Subsection 1 or subsection 2?
Right now I'm just looking at A. So the portion of 264-1A before subsection 1.
All right, but it says public highways are of two types. Subsection 1, state highways. Subsection 2, county highways. Subsection 1, state highways, which are those lands subdivided and acquired in accordance with policies and procedures of the Department of Transportation. So I'm just trying to figure out how this was a 264-1 public highway as of March 15, 2018.
Right. So again, so our position is that under 264-1A. So and again, looking at the question before number 1. So the road when it was built and opened and met that definition of a public highway. So then, you know, 264-1.
So it was a state highway. It was a state
two,
highway.
I believe so at that time, yes. But then, you know, because the Hawaiian Home Commission Act requires all public roads over Hawaiian homelands to be maintained by the county.
A1 does say that if it's a state highway, it's to be acquired and fee by the Department of Transportation. So you are conceding that that did not occur. Is that right?
Well, it was always the state has always owned fees. So my position is that the 264 requires a state highway to be owned by the state in fee, which even though the Hawaiian homelands are have trust responsibilities, they are still state lands owned in fee by the state.
All right. So, was the road actually subdivided?
I don't know the answer to that question.
All right, Mr. Rayner, I'm going back to the joint statement on the jurisdiction of Mauna Kea Access Road, and I just have a couple of questions. I understood you earlier to say that ownership of the road did not transfer from the trust, but the statement says beneficiaries of the Hawaiian Homes Commission Act of 1920 do not own Mauna Kea Access Road. Those two things seem inconsistent. Perhaps I misunderstood.
Well, I think that, what at least I interpret that to mean is that it's the state as trustee owns the Hawaiian homelands, and that includes the land under Mauna Kea. Of course, the beneficiaries of the Hawaiian Homeland Trust have an equitable interest in that as beneficiaries, but essentially the title is with the state as trustee. And so, when I was speaking earlier, what I was trying to say was that the 2018 designation did not make any transfer of the title of the land out of the trust, and it didn't withdraw it from the trust in any way. So our position would be that it's still subject to trust obligations, even until at least at such time as that land is exchanged out of the trust.
All right. So the next thing I wanted to ask is, and this kind of comes back to the point you and I were discussing earlier, that the statement says that Hawaiian homelands were previously maintained by the County of Hawaii pursuant to a memorandum of agreement, but the statement notes that state DOT has controlled and maintained the access road since 2018. So the statement itself acknowledges some kind of additional rights that were acquired by the Department of Transportation that were not exercised by the county before. And your position is that those rights are so insignificant or not relevant to the determination of whether there's been a new breach?
Essentially, yeah, at least as in regard to the claims in this case, and what we really think this case is about, and what plaintiffs are really claiming here. Because like I said earlier, those types of arguments and claims that the Department of Transportation, like issuing permits that didn't exist before, and while we acknowledge that's true, those arguments were only ever made in the reply brief on appeal, and the claims in this case have always been about the compensation. And I think plaintiffs' counsel, I think, would agree that that is still probably the primary part of their claim, that the trust should be compensated for the use of that land for a general public purpose, being the use of a public highway. And again, our position is that is something that was resolved through Act 14.
And then I have one last question, and Judge Cahill and Justice Edens have questions. The statement says that it's a joint statement of the Department of Hawaiian Homelands, and there's a quote attributed to Chair William J. Isla that it indicates Act 14 was a historic piece of legislation. I guess by inference, it sort of indicates acquiescence. But does the record disclose whether this was a matter that was voted on by the board of the Hawaii the HHC, the Hawaii Homes Commission? Is this something that the chair has the ability to acquiesce in, or is it a board decision?
Well, certainly the record, I don't think there's anything in the record that shows that was voted on by the commission. But I think that the department's position has always been that it is, and there was testimony and evidence below that demonstrated that there's nothing in the plans or the budget of the department to have the ability or even the desire to have to take on the responsibilities of having control over a jurisdiction over a road. And in many ways, it's beneficial to the trust to have an entity like the Department of Transportation, and especially given in a case like this where none of the parties are arguing that the road should be closed. The plaintiffs have said repeatedly in their briefs and again today, I think, that they're not seeking to have the road closed. And so because of that, there's really no benefit to the trust or to the beneficiaries of the trust as beneficiaries to having the department be an entity that has to take on the liabilities of looking after a road. And so that's why the position of the parties have been aligned in this case.
Thank you very much, Judge Cahill, and then Justice Edens.
If I understand, Mr. Rayner, Act 14 was designed to compensate the trust for use of the roads between 1959 and 1988. Is that correct?
Yes, and any claims arising out of that, those uses, yes.
Right. But the plaintiffs are alleging that the breach of the trust occurred in 2018. Is there anything in Act 14 just by the face of the statute that would indicate that the legislature intended to bar all future claims, even if a new breach of trust.
So there is some language that suggests that what the legislature was trying to do was to bar, both claims that had arisen during that time and issues that could arise in the future that arise out of those claims or arise out of the uses that were being compensated for. And this is in section 4. It says that it would have to have the effect of res judicata all issues which had already arisen or could in the future be at issue. So as long as they rose out of the controversies beginning at that time. And so, I think that language in section 4 indicates an intent, very broad preclusive effect. And of course, we're not taking the position that there could never be another breach of trust. If the state was to, for example, do something like tear up the road and then just try to sell off the land for like well below market price or something, then sure, that could be a separate breach of trust. But anything arising out of the use of that land as a public road, which we believe is what happened in 2018, is precluded by the act.
Thank you.
Very well, Justice Edens.
Mr. Rayner, you mentioned that until there's the land exchange, pretty much everything is governed by Act 41. And I think I recall reading a declaration in the record here that basically was saying that as of 2019, Act 14's land transfer and exchange requirements remained outstanding for about 346 acres to satisfy the roads and highways requirement. And then I understand there was a 2021 House Resolution 76 that established a working group, and they emphasized the concern about the outstanding issues regarding the Mauna Kea Road. And then I think despite a request to submit a report by the 2022 legislative session, there's been no report. I'm just wondering that, if in the 28 years since 1995, if there was a land exchange, would we even be here?
Honestly, no, we probably wouldn't, because I think at that point, it'd be a little speculative to say exactly what the land exchange would look like, but presumably that would be an exchange that would take the land out of the trust and sort of replace it with separate land. And so I think you're probably right that yes, we probably wouldn't be here. But I think there was, and referring to that, the 2021 House resolution. There was also there was testimony to that resolution, which is in the public record from Department of Land and Natural Resources, which indicates that there are still transfers going on. I think at that time there was just over another 1,000 acres of land that was still pending transfer, and it sort of outlines some of the problems with delays in accomplishing all these things, and some of those, a lot of this land that the entities are seeking to exchange or transfer they have to be appraised. A lot of them have to be surveyed for the first time. There has to be beneficiary consultation. There has to be approval from the Secretary of the Interior. So it takes a long time, essentially.
So if it had occurred, you would have no issue then with the 26442 designation, because
when you say we have no issue, then there would be no question as to its legality.
For example, the state, if there was a land exchange, could designate it as a designated pursuant to 26442.
Yeah. Yes, I think so.
There'd be no problem. So you wouldn't have it. So then the whole issue about the thorough road, that's dropped.
I'm sorry, the whole issue.
So the whole issue about the through road specific property and all that, you would say that if the state had control, subject to a land exchange transfer pursuant to something that hasn't happened in 28 years, the 26442 designation issue is off the table?
Well, I think the only way plaintiffs get to that anyway is through their breach of trust claim. you know, and we don't believe there's a right to just to challenge that, you know, outright without, you know, they argued that they can get to it through their breach of trust claim, but there wouldn't even be a breach of trust claim because if an exchange had occurred, then the land would have been transferred out of the trust. So there would be no basis to bring that claim, I think.
Well, okay. And just for clarify, I'm not talking about the breach possibilities. I'm just talking about designating the system if the state had full operation and control. But thank you.
Yeah.
For your.
Yeah. I mean, and also, I mean, you know, without the land being in the trust, I mean, I think that it would have to be either a county or a state highway, and so I don't think we would have the same issues necessarily.
Mr. Rayner, we were asking you questions during your rebuttal time, so I want to give you the opportunity to wrap up here and raise any further points for the court.
So I'll just try to wrap up very briefly. So ultimately, we don't believe there is any new harm to the trust or to the trust beneficiaries arising from the 2018 designation that didn't already exist prior to July 1st, 1988. So that 2018 designation, it didn't transfer title, it didn't remove the land from the trust, and nothing about the possibility of the Department of Hawaiian Homelands one day potentially having to obtain a permit from the Department of Transportation for some unspecified action causes any harm to the trust or the trust beneficiaries. And you know, no one in this case, just to reiterate, is arguing or seeking to have Mauna Kea Access Road closed as a public road. So we think this case is really only about one thing, and that is the question of how the trust is to be compensated for the fact that the state took that land and used it as a public road without properly withdrawing it from the trust back in the 1970s. And our position is that that was resolved by Act 14. And as a result, plaintiffs' claims and the relief they seek are barred.
Can I just follow up on one thing, Mr. Rayner? You've said repeatedly it's only about compensation, but wouldn't it also be about which entity, the Department of Transportation or the Hawaiian Homes Commission, would have the ability to make decisions about proper uses of this road?
Well, I think that the reason we kind of say that is I think plaintiffs have taken the position at times in this appeal that it is not just the fact that the state control the road that would be a breach of trust, but also the county, because the county is operating it as a public road when it was never properly withdrawn from the trust in the first place. And so essentially, I guess the point I'm making is that I don't believe that just a designation that the Department of Transportation is not in control would really resolve the claims in this case, because I think the claims in this case are ultimately about a compensation to the trust.
Very well. Thank you for your argument. We'll turn now to Ms. Obrey for her rebuttal.
Thank you very much. So I'm glad there was further discussion on 264-42. I realize I failed to really emphasize the fact that it has to be a public highway to start. That was an assumption that was in my head. But the state is calling the 2018 action an administrative change that didn't transfer title out of the trust. We know that a designation requires a transfer of title, and without that title, they cannot assert authority over it. So regardless of whether the lands are state or not, the road could not have met the definition of a county or public highway under that provision. And so it's trust lands that must go to the benefit of the trust. It means that there are trust duties owed to protect the trust property and to use it for the benefit of beneficiaries with those high fiduciary duties we've been talking about, and also removes any dispute that the plaintiffs prevailed on the merits of this breach of
Justice
trust
McKenna
claims.
had a question.
And it may be even... Oh, sure.
In terms of one of the arguments from the state defendants, is it your position that if all of the land exchange had occurred, because there doesn't seem to be any dispute that hundreds of acres under Act 14 have yet to be transferred, is it your position that if the transfer of those lands had occurred, then you don't have a claim? Because I understood your position to be that the 2018 transfer was a new breach, separate and apart from what was covered by Act 14.
Correct. Even if there was a land exchange under Act 14, Act 14 does not expressly identify which lands would have been exchanged. So there's no telling if that would have included this road. I mean, if we're making the assumption that it did include this road, then perhaps yes. I mean, at that point, the land prior to 2018 may have been under a jurisdiction of a different state agency. But based on the language of Act 14 itself, there's no indication that this particular road would have been exchanged. So
that wasn't actually my question. I'm just assuming.
I'm sorry.
This road would not have been a part of any exchange because the title, it had been reverted back to DHHL from the LNR. My question is, what if the Act 14 land exchange had been completed? Would that get rid of your claims? I understood your position to be that Act 14, the Act 14 settlement does not affect your 2018 breach.
I hear what you're saying. Sorry. No. So because Act 14 was specifically about public use, and that is not what we're talking about here. We think about the test for res judicata. Could the plaintiffs have sued back in 1988 for what they're suing for now? And clearly the answer is no, because in 1988, everybody recognized that this was DHHL property. There's no reason to believe that anyone was going to take the land from DHHL 30 years later. So all that to say, it's not acceptable to shut out ways for beneficiaries to bring forward actions to ensure enforcement of the trust based on Act 14.
Ms. Obrey, again, trying to understand the relief you're seeking. Would you be asking us to invalidate the, I guess, designation, I want to use the right term, of this as being a state highway that's under the control of DOT and then return matters to the pre-March 15th, 2018 situation where it was Hawaiian Homelands had jurisdiction over the land with an agreement by the county to maintain it. In other words, what I'm trying to understand, do you want us to say that this designation was invalid?
Essentially, yes, that this is not a state highway, that this land is Hawaiian homeland. So, I mean, how that plays out, yeah, I assume that reverts back to what it was pre-March 15th, 2018. But in terms of the declaration, just very specifically, that this is not a state highway. This land is Hawaiian Home Trust land.
Thank you.
You're welcome. So the land never transferred out of the trust. I mean, it kind of leads me to believe, I mean, maybe the DOT is a squatter. There's no authority to control the road. I mean, that's kind of where we're at with this breach of trust, right? The authority belongs to DHHL, not to the Department of Transportation. A couple more quick points that I wanted to clarify that the record is sparse simply because, as we know, there was no underlying transaction. The record was developed. The defendants never brought in any evidence to dispute the evidence that plaintiffs put in. We know that there was no consultation with the commission or beneficiaries. There's no following of the process, and that's what makes this so problematic. I think a lot about justice, and we've looked at in the briefs and in the motions below, there's testimony from our clients talking about the impacts to connection to INA, the connection to being able to generate income for homesteading and address the wait list. And the Hawaiian Homes Commission Act was really meant as restorative justice. We think about how that's meant to uplift Hawaiians, put them back on the land. And even Act 14, though not totally or fully implemented, was similarly meant to resolve past harms, restore the trust and beneficiaries. It is the state who has not implemented Act 14, so to see the state use that act as a way to keep beneficiaries down is so far inconsistent with the purpose and spirit of the Hawaiian Homes Commission Act, and it's really hard to watch and to see and to listen to, and just have to make that point because all of these arguments are truly just affirmative defenses and distractions from the undisputed record that this was a taking in 2018 for the very first time, that the trustees failed to do anything about it, and that this case is about stopping those breaches. The trustees joined with the state. They didn't join with their beneficiaries. That's why the plaintiffs are here. So precluding the suit from going forward improperly shuts down remedies for beneficiaries, and that's not acceptable. So again, if we look at the idea that the Hawaiian Homes Commission Act aims to make Native Hawaiians whole, to heal the damage done to Kanaka, return them to the land, promote self-sufficiency, cultural preservation, that's the metric this court should judge the state's actions. Them taking control without any, land disposition, any transfer of title, taking control away from DHHL without compensation does not advance any of the Act's purposes. And so there is no conclusion you can reach except that defendants did breach their trust duties. And because this breach had nothing to do with public use and is 30 years outside of the Act 14 claims period, there's nothing preventing plaintiffs from obtaining all the relief they seek.
Anything further for the court at this time is over.
I have nothing further unless there were other
Very
questions.
well. I want to thank both of our attorneys today for your arguments. The court will take this matter under advisement.
Ua ho'oku'u ia mai ni ke aha ho'okolokolo ki'iki hanohano o ka moku aina o Hawaii. This Honorable Supreme Court of the State of Hawaii is now adjourned.